Hi, my name is Tom Grzesik, and I'm one of the attorneys here at Fleit Intellectual Property Law. For this segment of the IP Minute, I will be discussing 3 advantages and 3 disadvantages of provisional patent applications. But first, I will give a brief overview of what a provisional patent application actually is. A provisional application is basically a simpler, less formal version of a regular patent application, otherwise known as a non-provisional application. Provisionals are not examined, nor do they issue into a patent, and they have less filing requirements than non-provisionals. In addition, provisional applications expire within 1 year from their filing date. However, within this 1 year, you are able to convert the provisional into a non-provisional application that can claim priority to the earlier filing date of the provisional. This leads us to the first advantage on our list, which is an earlier filing date. The U.S. and most other countries implement a first-to-file patent system. This means that the first person to file a patent application for protection of a given invention will receive priority over all other applicants for that invention. Therefore, obtaining the earliest filing date that you can is very important. Now, in some instances, you may not be ready to file a formal non-provisional application for whatever reason. However, you can still secure a filing date for your invention through a provisional application. As previously mentioned, once your provisional application is filed, you will have 12 months to convert it into a non-provisional application. If your non-provisional application is filed within these 12 months, then the earlier filing date of your provisional will be applied as the effective filing date of the non-provisional application. What this means is that any patent applications filed after your provisional will not be considered as prior art by the Patent Office, even if they are filed before your non-provisional application. This also applies to any additional publications or products that become available after the filing date of your provisional application. The second advantage on our list is that provisional patent applications allow you to work within budget constraints while still allowing you to secure a filing date for your invention. For example, provisional applications have lower government filing fees and typically have lower attorney fees due in part to less filing requirements. So if you do not have funds to file a non-provisional application, you can still secure a filing date for your invention while using the next 12 months before the provisional expires to secure additional funds for your non-provisional. In addition, you may want to first assess the market value of your invention or further develop your invention. A provisional application will allow you to do these things without spending the additional funds on a non-provisional application. Also, as you further develop your invention, you are able to file multiple provisional applications to cover these developments. All of your provisionals can then be combined into a single non-provisional application. The third advantage on our list is that provisional patent applications allow you to secure a filing date for your invention even though you may be facing significant time constraints. There may be some activity or event occurring within a time period that would make filing a formal non-provisional application difficult or impossible within these constraints. For example, you may be disclosing your invention to investors, starting a crowdfunding campaign, and there may be some other event or action that would trigger a 1-year grace period. Since provisional applications have less filing requirements than non-provisional applications, they can usually be prepared and filed in a much shorter period of time. Therefore, even though your time constraints may not allow a non-provisional application to be filed, you can still secure a filing date for your invention through a provisional application. Although provisional patent applications have many advantages, they are not without their disadvantages. One of the disadvantages is the possibility of unnecessary or additional costs. For example, the government filing fees and typically the attorney fees previously incurred for a provisional application do not apply to the later filed non-provisional application. Therefore, the costs for a provisional application add to the overall costs of securing protection for your invention. This may not be an issue for you if the advantages of a provisional outweigh the additional costs. However, if a provisional application is of no benefit to you, then its associated costs are likely unnecessary. The second disadvantage on our list is that a provisional application can give you a false sense of protection. Filing a provisional application does not necessarily mean you will have adequate protection for your invention, since a provisional is only as good as what you disclose. If your provisional application fails to adequately describe your invention in detail, your invention may not be fully protected under U.S. patent laws when you file a non-provisional application. The details in your non-provisional application must be supported by your provisional application. Details that are not supported by the provisional will likely not be able to benefit from the earlier filing date of the provisional application. This happens in many instances where an individual or even an attorney files a very short provisional and then adds additional details to the non-provisional that were not in the provisional. The last disadvantage on our list highlights an issue that may arise with foreign filings. In many foreign countries, the timing to file a patent application is based on your earliest filing date. What this means is that if you go to file a provisional application in the United States and also intend to file a non-provisional application in a foreign country, you may need to file in that foreign country at the same time a non-provisional application needs to be filed in the United States. This can be an unexpected cost and a timing issue if you do not plan accordingly. So I hope this was a helpful introduction to understanding some of the advantages and disadvantages of provisional patent applications. If you need further information regarding provisional applications or any other intellectual property law issue, please contact me via our website, fleitip.com, for a free consultation.